Good morning, I'm Gary DeWaal, and this is Bridging the Weeks for February 26th to March 9th, and today is March 12th, 2018. A United States federal court, the U.S. Department of Treasury, and the Securities and Exchange Commission all issued views on the regulation of cryptocurrencies that suggest a growing complexity for market participants. Separately, a defendant in a criminal action alleging that initial coin offering he orchestrated constituted an illicit sale of securities argued that cryptocurrencies are not securities as they are currencies, and that currencies are not included in the definition of securities under applicable law. Moreover, digital tokens issued in initial coin offerings do not take value from the significant or sole entrepreneurial or managerial efforts of others, he said. Last week marked International Women's Day, and observances were held around the world vocalizing support for the Me Too movement and equal treatment for women in business and other opportunities. I have never understood the failure of all persons to treat all other persons with respect and decency under all circumstances and at all times. But unfortunately, I have no time for philosophy, as we have a few interesting events in financial services to cover. So, let's get started. Last week, there were three major developments involving regulation of cryptocurrencies in the U.S. First, a federal court in Brooklyn, New York, affirmed that the Commodity Futures Trading Commission has the authority to bring an enforcement action against a person that is engaging, or may engage in fraud involving a virtual currency, even if the transaction does not involve a futures contract or other derivatives contract based on a virtual currency. Second, the U.S. Treasury Department released publicly a letter sent privately to Senator Ron Wyden in February, stating that developers or exchanges that exchange initial coin offerings issued coins or tokens for fiat or virtual currency must be licensed as money service businesses by the Financial Crimes Enforcement Network unless otherwise registered with the CFTC or the SEC and comply with all applicable money service business anti-money laundering obligations. And third, the SEC again stated that all cryptocurrencies constituting securities may only be traded on or subject to the rules of a national securities exchange unless exempt from such requirements, such as on an alternative trading system under SEC regulation ATS. Unrelatedly, on February 27th, Maxim Zaslavsky moved to dismiss a criminal complaint that had been filed against him in November 2017, charging that he engaged in illegal unregistered security offerings and securities fraud in connection with the offering of digital tokens, REcoin and DRC, through initial coin offerings organized by two of his companies, REcoin Group Foundation and DRC World. Among other things, Mr. Zavalisky claimed in his motion that the digital tokens he tried to create were not securities but cryptocurrencies, and that all currencies, fiat or otherwise, are not securities under applicable law. Indeed, claimed Mr. Zaslavsky, the Securities Act of 1934, one of the relevant laws, expressly excludes currencies from the definition of a security. Previously, REcoin, DRC World, and Mr. Zaslavsky consented to the entry of a preliminary injunction and asset freeze in response to an SEC enforcement action alleging that they engaged in a fraudulent initial coin offering from July 2017 through at least September 2017. The SEC takes a very broad view of what constitutes a security. I have some strong views on this on the article version of Bridging the Week at www.bridgingtheweek.com. Check it out. Three New York Stock exchanges agreed to pay a fine of $14 million to settle allegations by the SEC that, as a result of various episodes from 2008 through 2016, they failed to comply with various laws and regulations governing registered securities exchanges. The three exchanges were the New York Stock Exchange, NYSE American LLC, and NYSE Arca, Inc. Among other things, the SEC claimed that from 2008 to 2015, the interaction between two types of order types of NYSE and American, pegging orders and non-displayed reserved orders, potentially enabled floor brokers to determine the presence, but not the quantity, of non-displayed pending debt liquidity on the exchange's order books without disclosing this possibility in its rules. The SEC also charged that, for approximately 1 year after November 3rd, 2015, NYSE and American did not have, quote-unquote, reasonably designed backup and recovery capabilities as required under SEC's regulation SCI, and then on August 24th, 2015, ARCA had a large number of limit up, limit down trading pauses that were largely caused because the exchange applied price collars to market reopenings following trading pauses. However, said the SEC, while ARCA's rules describe price collars for opening and closing auctions, they did not for reopening auctions. Thus, the exchange did not comply with its own rules regarding reopening auctions, claimed the SEC. And finally, Thibault Blayhart agreed to a 3-year ICE Futures U.S. access prohibition to resolve charges brought by the exchange that from March 2016 through March through May 2017, he traded coffee C futures on 27 occasions to transfer funds from his employer's account to his own. According to IFAS, during the time, Mr. Blayhart had authority to trade his employer's account. Mr. Blayhart also agreed to pay a fine of $40,000 US to resolve this matter. Well, that's it for this week's edition of Bridging the Weeks. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. That's at www.bridgingtheweek.com. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.